Welcome and thank you for joining us today. My name is Emily Spranger, and I'm the Associate Director of Endowed and Gift Planning here at Grand Valley State University, and I'm excited to join my colleagues in Alumni Relations for today's webinar. Today we're focusing on estate planning, and it's part of a monthly series called Retire Well, which brings you an array of information as you prepare for or embrace retirement. Just a few housekeeping notes as we get started. If you have a question at any point, please use the Q&A box on the bottom of your screen to send those to our presenters. And during the webinar, we'll drop some helpful links in the chat as we go along, and we'll share some additional information in a follow-up email as well. And feel free to use the chat to introduce yourself and drop your grad year, and introduce yourself to all the other guests we have. So we'll jump right in. I'm pleased to introduce alumna Melissa Stewart to facilitate today's presentation along with Tim Alice. I'll hand it off to you, Melissa.
Great. Thanks for the introduction today, Emily. I really appreciate that. Can you see my screen? Just want to make sure. Okay,
Looks
great.
good.
Great. So my name is Melissa Stewart, and I graduated from Grand Valley State University in 2009. I was a double major in finance and business management, and it's what my passion is. So I've been a financial advisor in the financial advisory industry now for about 20 years. After I graduated from Grand Valley, I went on to get my certified financial planner designation, as well as an accredited investment fiduciary. So what Clear Vista Advisors does is we primarily work with pre-retirees and retirees, helping them figure out everything that they need to know in retirement. The series came about because I had an HR director reach out to me and said, hey, we have a whole bunch of people thinking about retirement. And would it be really nice if there was a course they could take that could set them up? Social Security, Medicare, estate planning, long-term care, right? There's a lot of things. How do you change your investment strategy? And so that's what this series is really about. Clear Vista Advisors, after working for a Fortune 500 financial advisory firm for many years, I started Clear Vista Advisors, which is 4 years old, and we are a fee-only independent fiduciary financial advisory firm. So we really look to make sure that we make recommendations and advice that are in our clients' best interest. So as part of your call to action today, if you want to connect with me, here are the QR codes. Feel free to send me an email. I'd be happy to meet with you after today's session and kind of go over your financial situation. That consult is no cost. As well as, I'm going to plug Tim here in a minute, but his firm does the same thing where they'll meet with you and do a complimentary consultation. I also want to remind you that we have a couple other sessions coming up here. There will be 2 more in the spring, but there's a couple more sessions. Let's get over to that slide right there. Assuming the government is back open by November 13th, we have Maximizing Your Social Security, where we will have the public affairs specialist from the Social Security Agency providing that presentation. Should the government not be open by then, we will send a new date for that and re-register anyone who signed up for that. So be sure to make it to that session as well too. And with that, that's everything I had today. Oh, one last piece is I want to say that a lot of people don't really think about, what would my financial advisor have to do with estate planning? But as Tim goes on today, you're going to find out that there's a lot that your financial planner has to do with estate planning. So my goal when I work with people is really to kind of be a quarterback of their financial life, right? Their own personal CFO. And a lot of that has to do coordinating things with your attorney, like how are your accounts titled? What are your beneficiaries? Do we have everything set up appropriately there? As well as with your CPA if you're working with one. What are tax minimization strategies that we can implement? So a good financial advisor can really help coordinate all of that for you. But with that, I'm going to give a little introduction to our speaker today. I have had the privilege of now working with Tim for almost 10 years. He does estate planning for a lot of my clients, or his team does. Tim originally founded Alice Law, which is now Generation Trust Law Group, to educate and advise his clients in ways to protect themselves from an unknown future. Tim takes complex, which you'll learn today, legal, principles and really makes them easy to understand. And we'll talk a lot about that more today. Um, Tim develops personalized strategies for individuals and families to create an estate plan that protects their future. Whether you have a young family, or today we're going to talk more about what does this look like as I think about retirement. But really, really, everyone needs to have an estate plan in place, and Tim will talk exactly about what that means today. If Tim wasn't an attorney, he says he would be a professional golfer. So true, Tim?
Yeah, yeah,
And when he's not busy running his law firm, he's spending time with his wife and two children. He is a Hope College grad, but we won't hold that against him today. So with that, Tim, I will stop sharing my screen. And I'm going to moderate today, ask some questions along the way. We want to make this really, really interactive. So please be sure to put some questions in the Q&A as we go along. It makes it more fun for Tim. It makes it more fun for me. And then you can make sure you get your questions answered along the way as well. With that, pass it over to you, Tim.
and thanks to the GVSU team for having me here today. As Melissa said, I'm an attorney. I really focus in two primary areas: estate planning, which is wills and trusts and powers of attorney, and then what we call estate settlement. If somebody becomes incapacitated, how do we now use these documents? And when somebody passes away, how do we use these documents? How do we settle the estate? We become alongside families in that in those two specific areas, and there's a lot to them. So today, let's see here. I thought it was going to cooperate. There we go. Kind of want to talk a little bit about estate planning in general, but I always want to start out with, I hear the question all the time, or the comment often, "Hey, Tim, I don't need an estate plan. I just don't need one." Well, the reality is I'd say, okay, maybe you don't, but if you have an estate, you need a plan for that estate. So what's an estate? It's just a fancy word for your stuff. The obvious assets would be checking, savings, your retirement plan, your house, maybe a car. But often forgotten is life insurance. Some people will tell me, "Tim, we don't have anything. We don't have a whole lot. So when we die, we don't have a whole lot to pass on." Well, if you have life insurance through your employer, or if you have in addition to your employer, you have a plan on your own, you die, that money's going to be paid out, right? So when we talk about an estate plan, we have to make sure that we're incorporating all of your assets, all of the things that you have into that plan. Because if you have any of that stuff that we just mentioned, you do have an estate, and you do want to have a plan for that. So what is an estate plan? Really, I like to say an estate plan is a puzzle. It's a whole bunch of different, what we call legal tools that we use depending on what your needs are. Those tools, the more obvious ones, were wills, trusts. Another thing that is often forgotten is how we own things, right? Ownership types. Ownership types. You might own your checking account in your own name, right? Well, what happens to that when you die, right? Who can take care of that when you're incapacitated? You might own an account together, right? So what happens when you die with that account? Does that become the person who survives you, or does that have to go through a probate process? So when we talk about estate planning, we have to make sure that we are using the proper legal tools, and that we have very intentional structure of how things are titled and how beneficiary designations are set. So as you can see here down at the bottom of this list here, beneficiary designations / TODs, and TOD is just short for transfer on death designation. So if you have a checking account, just like you would in your 403b or your retirement account, IRAs, life insurance, you can have a beneficiary designation on your checking account and on your savings account. And so those are actually legal tools. We use them all the time. And in most estate plans, they have wills, there's trusts, there's powers of attorney. If you have real estate, deeds are important. If you own a house, how is that titled? Is it in your name alone? Where does it go when you die? So we have to pay attention to all these things. And as Melissa mentioned earlier, a financial advisor is really, the word she uses, quarterback. They really are the one that's really truly in control of where all of this stuff goes. And so when Melissa brings me in to help her clients putting their estate plan together, I go to her and I say, hey, anything I should be thinking about here? How should we structure this? What should I be aware of before I meet with the client? Because really it's her relationship. She knows a lot about every client that she sends over, and she's going to have an understanding of how ownership types are and what some of the things that we should
Yeah.
be
If
be
you meet
aware
with
of.
Tim, he has a questionnaire to fill out in advance to get some information from
Yeah.
you. And if they're working with me, they just send it to me and I just complete most of that for them. Maybe I have a few things missing, but we can make it pretty easy for you. So
Yep. Yep. And so when we actually talk about putting an estate plan together, we use multiple legal tools. But before we actually decide what tools we should use, we need to figure out what's
Tim, what
important
do
to
you
us.
mean by tools? Are those the items that you just talked before? Like when you say
Yeah.
tools, what do you mean?
Yeah. If I go backspace here, a will is a legal tool.
Okay.
It serves a certain purpose. A trust serves a certain purpose. And what we have to do is we have to identify, like, how do we want this? What's the purpose here? Why are we doing this? And so what are your goals? Just like Melissa would ask you questions about, hey, what do you want to use your money for? When do you want to use it? That's what a good financial advisor will do. But these are really five of the goals that I hear the most. Up top, preserving family relationships. Often, people they fight. Kids fight when mom and dad pass away. Even the best of families do. And it is my job to help every client that comes in articulate what's important to them, right? Some people will come in and they'll say, Tim, we have got to avoid probate. Number 4 on the list here. And these are not in any order of importance, but avoiding probate is what a lot of people come into my office and say we need to do. And I said, well, what's probate? I don't know. Well, okay, why do you want to avoid it? Well, the answer is yes, you do. let's stay out of court if we can. But what legal tools do we use to avoid probate? Well, if we back up here, and we're going to kind of bounce back and forth here, a trust is the legal tool or a legal tool that you would use to avoid probate, right? A beneficiary designation you would use to avoid probate. One common misconception, however, is, does a will help me avoid probate? And the answer is no. The answer to that is, in the way that I remember this, is a will means you will go through probate, and that's true.
Tim, can we take a back step up here for those that aren't familiar with the term probate and what it means to avoid probate?
Yep. So probate, if you think about it, probate is all about authority. So if you think about your own checking account, who has the right to write checks off of that account, make deposits, and use that money? Well, you do. But if you become incapacitated, who has the authority, right? If you don't have and we'll back up here again, a legal tool called a financial power of attorney, then we're going to have to go to probate court for you, because the court can grant somebody the authority to write checks for you, to pay your bills, right? And the alternative to probate is a financial power of attorney on the money side of things. Who has the right to make your medical decisions for you if you're unable to for yourself? That would be your healthcare power of attorney. And if you don't have these documents, the county in which you live, we'll move back forward again here, will have the authority to give someone else, a person, the authority to make your medical decisions, to write checks for you, to work with your financial advisor to manage and invest your assets, right? Maybe sell your house. So probate during your lifetime, the legal tools that we use to avoid the court system is a power of attorney for financial matters and a power of attorney for healthcare matters. In order to avoid probate on death, because when you have died, you don't have authority over your accounts anymore. Who does? Well, if you have a trust, every asset that's in the trust, it's not going to go through probate. That would be your trustee. That person would have authority. If you have a beneficiary designation and your 401k, your life insurance, they go to certain people, it's going to avoid the probate process. It's a really easy way to just transfer property to whoever you want it to go to, right? So when we talk about one of the goals that people have is avoiding probate, it's really, really easy to do. We just have to make a determination on how we want it to go to the next generation or who's going to receive it.
So real
And that's
life
where,
situation here with a client of mine, and I would say this applies to those on the call today or on the webinar today, but also make sure your parents have these in place because it's going to make things a lot easier for you. I know that can be a hard conversation to have, but so important to have it and make sure. And it seems like those conversations happen about this time of year when we're heading into like the holidays, Thanksgiving, we're around family more. But real life situation here, client of mine she had to go into a nursing home, some signs of dementia, and she didn't have these documents in place. And so because these documents were in place, and she was no longer mentally capable of signing over these documents and making that decision, they had to go to the probate court to have a conservator appointed for her. And then that conservator can now manage her IRA, her retirement accounts. So even though she has beneficiaries listed on her IRA and on her retirement account, those beneficiaries don't go into effect until she's no longer with us. They have to have, if she was able to make decisions right now, they could have had her sign a financial power of attorney. But because she's no longer capable of making decisions, they have to go through the court system. And it's not a one-time deal. They have to go and get it renewed every year. And every year we have to work with Charles Schwab, because that's where the accounts are held, and give them the brand new paperwork. So it's easier to have it done in advance than it is to have to do it after the fact.
and that's a great point, Melissa. The goal number 2 here is ease burden for decision makers. If you put a plan in place, it's really a gift to the people who are going to stand in for you when you can't, because then they don't have to go to court, right? So when we talk about avoiding probate, yeah, we want to avoid probate, but really it's just making it easier for the people that you want to step in and make your decisions. Also the distinction is people do think, as Melissa mentioned, oh, I've got a beneficiary on that account, so they can take over. No, the beneficiary designation doesn't come into play until you pass away. When you die, the money then goes to the person that you've listed on there. So really, numbers 2 and 4 here, easing burden for decision makers and avoiding probate, they're really one and the same.
And I would say too, adding to that beneficiary part, like a lot of like spouses, right? We list our spouse as our primary beneficiary. But just because you're married, like for your IRAs or your 401k or your 403b, your retirement accounts, that it still doesn't apply. Like if you have a spouse, just because you're married isn't enough. You have to sign that financial power of attorney stating my spouse can manage my account if I'm not able to.
Yes, and also making medical decisions nowadays. I mean, hospital systems continue to consolidate and grow, and the lawyers within hospital systems don't want to say, if you're married, your spouse can pull the plug on you. No, you have to have authority to do that, and the healthcare power of attorney gives you the authority. If you don't have the healthcare power of attorney in place and you become incapacitated, then you got to get a court order, and that's called a guardianship in Michigan. So conservatorship for the financial side, guardianship for the medical side. So when we talk about putting together an estate plan, if these are some of your goals, it will inform us as to what legal tools we need to use. Number 3 here, the stupid question. one of the things that you have to think about when putting an estate plan together is who's going to get my estate when I die, but also what does it look like in their hands? Are they good with money? Um, am I concerned about them spending it all? Am I concerned about, we hear it all the time. Hey, Tim, our daughter got married and we don't really like her husband and we don't want her husband to get any of these assets. Do you want your estate plan to protect against a spouse of one of your children taking half of what you give to them? Well, that's a thing. And we hear it all the time. And yes, you can do that. It's not your job to come into our office and know these things right out of the gate. It's our job to ask you a series of questions to help you better articulate what you want to accomplish. Like for me and my wife, we've got 2 kids. They're teenagers, and we want to make sure that we are blessing them. So the stupid question is, do you want to bless them with the what you leave behind, or do you want it to be a curse to them? And our kids are young, and no, we do not want them to take our life insurance and when they're 18, because when you're 18, you are considered an adult under the law, and they can go spend the money on whatever they want. No, we want our kids to launch and be educated and be productive members of society. It doesn't mean they have to make gobs of money. They just have to be productive and put effort forth. And it's our job to make sure that they are blessed by this. And so we use a trust. And a lot of people think, oh, a trust fund, I don't need that for my kids. Well, you kind of do, right? If you have younger family, a trust fund is the best and easiest way to make sure that your kids have the resources they need for launching into adulthood.
I think we think of trust or trust funds being like really ultra wealthy, but that's not necessarily the case.
It's true. A trust fund, Melissa, you have a lot of trust funds that you manage, right? It's just an account. It's just a different way to name the account. So on this statement, it says the trust fund, or the name of the trust. And so, is it super complicated? No, it's pretty simple when done right. So when we look at the legal tool, I'm going to back up here again. Trusts, there are many types of trusts, right? And the most common is a revocable trust, and that means that you put your assets into it, or you make your IRA or your life insurance, you make your trust the beneficiary, so that when it goes on to the next generation, maybe you want to protect them from themselves, like I do for my kids, or you want to protect your children from maybe losing half of their inheritance to a divorce, or maybe they just got creditors after them, right? A lot of people come and say our kids are fine, they don't have creditors, and we always ask a lot of questions about the family that would be people that would be getting the money. And a lot of times you have creditors that it means that one of the kids is ultra successful. I mean, if you think about it, if you have a kid who's a doctor, well, doctors get sued sometimes, right? So that's a creditor. Can we protect against that? Yes, we can. Is it hard to do? It is not. But trying to paint a picture here for you to what would I use these tools for? Melissa and I have worked with a lot of clients over the years that they need a nursing home, right? And so there are certain kinds of trusts that can protect against being spent down for nursing home expenses. Are they the right tool to use? Often they're not, to be honest with you. However, we use them from time to time, and it really kind of, again, depends on what the goals and objectives of every client is. So
yeah, a couple other situations that we commonly run into is a couple of my clients have special needs children, and so an estate plan can help, done correctly, can help protect their benefit that they might be getting, their disability benefit that they might be getting from the government. Another situation that we run into, and Tim and I are not here to judge anyone's situation, but sometimes some of the kids would be like not responsible with their money. They're huge spenders, right? And so we can help protect them and make sure that they get money over time or a certain amount over their lifetime to, so that they don't just go blow it all at once. And sometimes there's substance abuse issues, right? And we're worried about that too. So once we get Tim gets his arms around what you have going on with your family dynamics, we can really be very specific in the legal language to help protect the situation.
Yeah, that's it. Those are great points, Melissa. I mean, when you think about a special needs situation, you're often addressing somebody who might not be able to work enough, if they can work, to support themselves. And most of the benefits available to individuals in that type of a situation are what we call needs-based benefits, meaning that you really can't have any assets in order to get those. Well, to get those benefits, what would cause you to go from having no assets to having a lot of assets, receiving an inheritance? And so if you have a situation where there's a child in that situation where you want to give them their inheritance in a special needs trust, because the government, when that trust is properly drafted, will not recognize those assets when determining eligibility for the benefits. So you want your child to receive an inheritance, but you don't want them to lose their government benefits, Medicaid, or in some sort of income source as well. So there are countless goals that people have. And what we do is we just use these legal tools appropriately to maybe avoid bad things from happening, and then also to make, hopefully bless and make good things happen for when you are no longer around.
So
So
what are the main differences between a trust and a will, Tim? Can you explain that? Because we did have a question that came in advance of today's presentation, and it was just talking about what are the benefits of putting my assets in a trust versus a will when you have multiple children?
yeah. So a will only becomes operative on your death. And the only thing the will does is it says, this is where I want my money to go. That's it. A will doesn't own anything. And on your death, if you have assets in your name and we want them to pass to, maybe your children, your will will dictate where that goes. But we have to go through the probate process with a will. So you have an executor, and in Michigan, that's called a personal representative. They don't have authority just on their own. They have to be granted authority by a judge in the probate process. And the judge would give, it's literally called letters of authority, that person would go to the bank, that person would go to Melissa and say, hey, mom had these accounts, and the will says that we need to redirect them. But that probate process is governed by the will. So the will doesn't own anything. A trust, however, is different. Think of a trust as a bucket, and you put things into it. You can put your checking account, your house. You can make your life insurance beneficiary the trust. So you can use the trust as a beneficiary for certain types of accounts, but the trust owns things. And on your incapacity, a person called the trustee would take over, and then your trust would say, hey, if I can't manage my stuff, take care of my money for me, right? Invest it, grow it, pay my bills. And on your death, your trust would say, where does this property need to go, right? And we don't have to deal with the probate court with the trust, right? So it's important, the distinction. Most people have both. If you have a trust, you also have a will, because what if you forgot an account, right? And we have to go through probate. Well, we want your will to pour over, we call it a pour over will, to pour the assets right into your trust. So you might have an account with just a couple $1,000s in it. Yeah, let's just have your will go through probate with that $2,000 account and give it to your trust. So we have a backup situation there.
And Tim, is it true that anything that goes through probate court is public record versus anything kind of titled in your trust stays private?
It's true. Yes. Courts are public record. People can get access to them if they want to, because part of the probate process is, okay, mom died, she's got all these assets. You actually have to share what's called an inventory. What did mom have when she died? And you have to list it all out. She had a checking account, she had a car, she had maybe some life insurance or whatever, and you have to share that. A trust, however, court never sees it, right? No, it is private, and that's one of the big benefits to having a trust is not everybody's going to know. The only people that would know what's in your trust are the people that are going to receive money from it. Yep. So, one of the things that we often run into here is, blended families, and blended family planning is it's a little more complicated because, you know, if a couple is married and then he has his own kids and she has her own kids, well, you got to think about, what do I want if I die? Do I want my spouse to get some of the money, or do I want my kids to get it? And so it's generally a little bit more complicated. So one of the issues that we address a lot with blended families is making sure that your children like your spouse, right? You know, if you remarry and you have kids, you want your new spouse or your kids to like your new spouse, right? Well, how do we make sure that that happens? Well, we can't make sure, but we can do some things that make it feel like, oh, you know what? This guy is not trying to take mom's money, right? So there's a lot of things that we can do to actually improve relationships in blended families, and we deal with them all the time. So what legal tools we use, you know, it depends. We're going to use trusts, wills, and who's going to be the decision makers. A lot of times we say, hey, have it be your kids. You know, maybe your spouse can be a decision maker on the medical side as well, but every situation is different. So I just wanted to bring this up because we see this every day here. What I want to do here as well is I want to say, when you're putting an estate plan together and you understand what your goals are, you gotta make sure that you're not improperly using legal tools. So there's often competing goals, and I guess an example is if we want to avoid probate, one of the legal tools that we can use is called a ladybird deed, right? There are a lot of different kinds of deeds, but a ladybird deed is like a beneficiary. You're putting a beneficiary designation on your house. So any real estate that you have, you can use a ladybird deed. So if I said, hey, when I die, I want my kids to get my house, and I used a ladybird deed and I want it to go avoid probate, great. You know what? I just avoided probate. When I die, it's going to go right to my kids. However, when it goes to multiple people, how many people need to sign the deed to sell it? Well, if it's going to two, there's two people. If it's going to four, it's four people. An example that I use often, and this is a number of years ago, is a family got advice from their attorney saying, hey, you can use a ladybird deed and the family farm can avoid probate and it'll just go to your 5 children. Well, that turned into a disaster. Hey, great. Mom and dad, when they passed away, they avoided probate. Awesome. Except for 2 of the kids said, let's sell it. 2 of the kids said, this is a family farm. We have to keep it in the family. And one said, hey, you know, I don't care what we do with it. Well, the 2 kids that wanted to keep it couldn't afford the taxes, right? And they weren't farmers. They didn't want to farm it. So after several $100,000 of legal fees, not to our firm, we don't do the litigation side, they figured it out and they ended up selling the property, and all the kids got a lot less money from the sale of the property than they would have. But the caution here is, you know, you can put a beneficiary on things. If you say, I want to use a ladybird deed to give it to 5 people, that can cause a big problem. If you ladybird deed it to a trust, the trustee can say, hey, anybody want to buy it? Here's what the value is. You can pay the trust and then we'll split the money 5 ways. Or if they just the trustee can say, I don't care if you want it, we're going to sell it on the open market. And then we can split the money, because you can't split property like you can split a checking account right down to the penny. So the improper use of those legal tools, and often too, we see people just put beneficiary designations on accounts. Well, Melissa, from your perspective, if let's just say I named you the beneficiary of my investment account, what would happen to that account if you died before me?
Right. Then it was going to go through the probate court system.
Yeah, the beneficiary is gone. So then it has to go through probate, and then suddenly I don't know where it is. So naming a person a beneficiary isn't always the best idea. If you name a trust the beneficiary, one of the things that we often do is we always have to ask, who will be alive when I die? I mean, if you're a parent, you never want, I mean, you want to go before your kids, you always do. However, we have it all the time. People call and say, hey, my son died and I don't know what to do. All right. What do we do with the accounts and
Mm-hmm.
whatnot? But
Do you
if we
want
get
that
it
to
to
go
the
to your
trust,
son's spouse? Do you want that to go to your son's children and skip the spouse? Do you want it so that, if you had 3 children and all 3 were listed as beneficiaries, do you want to completely skip the son's inheritance, not spouse, not children, and just have it go to your other 2 children, right? These are questions we have to answer.
absolutely. And when we talk about the legal tools here, a trust allows you to say, if this person has died when I die, I want their share to go here and then here. So we don't know who's going to be alive when we die. But a lot of people will do this because they want to direct the money somewhere else, but they'll do it because they want to avoid the money going to somebody, right?
Mm-hmm.
The last thing you want is for that one person to get any of your money. Well, if you don't plan properly, and you improperly use legal tools like a beneficiary designation, money could end up in the wrong hands. And you
Mm-hmm.
want to avoid that. And that's what a good estate plan does. We're not talking about rocket science here. You just have to think through these things. And it's our job to help you understand what's important, articulate that, and then put that puzzle of legal tools together, title things properly, update beneficiary designations, and then coordinating your attorney well with your financial advisor. They make your life a lot easier when you're putting an estate plan together. So people often ask then, hey, when should I create an estate plan? When should I, and if I have one, when should I update it? Well, this is just a list of things, but the general rule that I say is like, there's 2 things: life changes and laws change, right? So my rule is, if you have a plan in place, by the time 10 years from the time you put that plan in place comes up, you really need to redo your plan. Likely your life has changed a fair amount over a 10-year period, number one. And number 2, laws have definitely changed. And we had some very recent, pretty big sweeping law changes that affected estate planning and tax planning, and it changed financial advisory business a fair amount, as it pertains to IRAs and retirement accounts. And Melissa knows all those rules. But when it comes down to it, if you have a diagnosis, let's just say of dementia, well, life is going to change. It might not be an immediate impact, but life's going to change. And do you have a plan in place? If you've been diagnosed with something that you're probably not going to be around for a while, long, you might die soon, you got to get your plan in place. If you get a divorce, do you really want your ex-spouse to have your life insurance? Probably not. If they're going to make your decisions on your incapacity because they're your healthcare power of attorney, you don't want that, right? So you got to update your plan then. And this is just a list. People will ask me, "Hey,
Mm-hmm.
is this a good time to update my plan?" Well, here's a list of ideas of when to do it. So that
So moving
really,
to a different states had
yeah,
different rules, different laws for your power of attorney and your health directives, in your trust, your will, they all have different rules. So you have to really get it redone if you do move states. Um, and one of the things, like when I'm talking to my clients that haven't updated theirs in 10 years, that's really newer, I would say, is your digital rights. So I use my cell phone, as my camera, right? I take a ton of pictures on this. And I want my children to have access to those pictures. But if I don't have it properly set up that certain people have rights to my Apple iCloud account or your Android account, if I don't have that language in there, then they're going to have a really hard time getting access to it.
yeah, that's a great point. And um, passwords. A lot of people now save documents in the cloud. Melissa, and you've got an online portal for clients, right? They can go and access their
Mm-hmm.
information. Well, if they don't have a password, they can't access it. That's a big thing nowadays. And
And nowadays there's a lot of two-factor, right? Or pass keys, right? Because we're trying to make it harder to get into these accounts if you're not supposed to. Well, that's tough for your loved ones when they don't have the two-factor or the pass key for it.
it is. And the digital assets are what we're talking about here. And those must be addressed in your trust, because digital assets don't just go away when you die, right? But also in your power of attorney, your financial power of attorney must address those things, because more and more things are going into the cloud, and they're just out there, and you want to be able to make sure that people have access to those. One other thing that you should know as part of an estate plan is what do you want to do on your death? What memorial instructions do you have? And we make it easy. We don't. I'm not necessarily advocating that you go to a funeral home and do all the pre-planning. You can, but we have a one-page form. In Michigan, you can name somebody who has legal authority to make all of the decisions about burial, cremation, however you want. But if you want to see a family fight, I mean, because I've seen it, kids fight over, hey, mom wanted to be cremated. No, she didn't. And, mom didn't want a service. Yes, she did. So those are just things that are part of a plan that can reduce the risk of fighting. And we can't eliminate fighting, but that's just part of a plan. What's going to happen when I'm gone.
I've
So
seen so many families that get along, oh, my kids are great. It's a great family. We all get along, great kids. But the problem is that they are grieving the loss of their parent. At the same time, they're trying to figure out who gets mom's china, who gets dad's pocket watch, who gets, it's just, there's so much. So the more detail, which Tim has these documents in there, even like personal items, right? If we can decide who gets what, if you can decide that in advance, then the kids don't even have anything to argue over, right? So write that down. And then too, they get along really well, but it's down to the property, right? Like in my own family, my dad and my aunts couldn't agree as to whether they sold the house or not, or whether they rented it, but it was the house they grew up in. So there was a lot of emotional attachment to it. They did they didn't end up selling it, but there was a whole bunch of conversation that happened before they decided to do that. Versus if, my grandpa had just been like, sell the house, split the money, well, then they wouldn't have had a choice, right? They would have stopped the conversation right there. So
absolutely. Yeah. How you want to direct tangible personal property is a huge part of any estate plan. And we tell people handwrite those things. And we provide a list. It's just a blank list where you can say, I want the china to go to this person or these people. But there's some additional believability in when it's written by hand. So it's part of an estate plan that we do. And you can always update it too. So that for me is what I have today. Melissa, are there any questions out there?
yeah. Well, one thing to bring up, if please ask questions in the Q&A if you have questions. I've been monitoring it. We only had a couple come in. But one thing I was going to say is, like, even when you're younger, you have to have this. Like my friends, Phil and Ashley, they didn't even have any kids yet, but they were in a really, really bad car accident. And had they had these documents in place, it was probably like a month that they were healing. Someone needed to take care of their financial affairs. Someone needed to take care of some of their healthcare decisions. And so no matter your age, even your children, if you have children in their 20s or 30s, one of the things we tell people before they have kids go off to college is to get these documents in place when your kids go off to college, for them, so that if something happened to them, you can take over for them if you need to. So that was one point. And then Tim, we didn't touch upon charity at all. Like let's say giving is something, to Grand Valley. Let's say giving to Grand Valley is something you want to include in your estate plan. What would that look like?
I think the team can answer this better than me, but we often have people say, hey, I want to give to a charity or charities. There's so many ways to do it. And you can do it by beneficiary designation from your IRA if you want to. You can do it through a will or a trust. But when it comes down to it, you want to do it in a tax efficient way so that the charity gets more, the IRS gets less, and your children get more. And Melissa and the team at GVSU can help you decide what's the best way I can do this. What's the easiest way? You can make it very simple, or you can get pretty complicated with that kind of planning. But one of the things that we believe is that let's make this as simple as we possibly can. And honestly, beneficiary designation on your retirement accounts is probably the easiest way and the best way to do it.
Yeah.
What
On
do you see,
your like
Melissa?
pre-tax, like your IRA typically, or your tax deferred account. And the reason for that is because if you gave money, let's say you had money in your bank account or money from the sale of your house, right? That's after tax money. You've already paid taxes on it. But money in your IRA hasn't had taxes taken out of it yet, right? It's pre-tax money. And so if you give that money to your children are going to have to pay taxes on it. When they take it out of, they'll get an inherited IRA and they're going to have to pay taxes on it. Versus if you gave that money to charity, the charity is going to inherit that and there's no taxes due on it. So if we give it through your IRA, then we can leave more money in the after tax accounts, right? Your bank or your Roth to give to your children. And so at the end of the day, if you end up paying less in taxes, then those that you want to get your money, your children, the charities, there's more money left behind, right? Because we're paying less in taxes. So,
Absolutely.
okay, so we do have a question. Thank you for submitting it. How long does it take to initially set up an estate plan? And I wrote this question down too. What is the typical cost?
Yeah, great question. How long? It really depends on the complexity around your estate. We usually target under a month. If you come in from the time that you first come in till the time we sign everything, it shouldn't take any more than a month. Again, it depends on how many moving parts you have, right? If you've got a business or you've got multiple properties in different states, yeah, it might take a little bit longer, but a month is a good rule of thumb for me. And the cost, it kind of depends. I mean, it depends on what legal tools. I mean, if we were to kind of go back here, what legal tools do you need? What level of complexity do you have? So, if you want a complete plan, trusts, wills, financial powers, healthcare powers, appropriate deeds and retitling of everything, working with the advisor, you're talking about 4,000 to, I mean, I would say 4,000 to 6,000 is a pretty typical fee to finish all of it and do all of it. But we have had clients that pay more because they need it. They have more money. There's more complexity. So yeah, I would say 4,000 to 6,000 is a pretty good range to get a
And I
good
tell my
complete
clients you
plan.
either end up paying it now or you end up paying it later, because if you don't have these documents in good order and you do have to go through the court system down the road, then your children are probably going to end up hiring an attorney to navigate that. And they're going to end up spending, hiring an attorney on retainer to help get through that process. $5,000 retainer, maybe ish. I don't know. Tim, you would know better than I, but I just tell people either you spend the money now or you end up spending it later, because the kids will need help navigating the court system typically.
Yeah, and if you think about it too, if there are things you want to avoid, like young kids just at 18 doing whatever they want, blowing the whole estate, or losing half of an inheritance to a divorcing child, what you pay is, it's like adding a little bit of an insurance policy or a layer on top of protecting your estate from the things you don't want to happen. So
Yeah.
there is value added to it. It's an investment.
All right, last chance for the Q&A here. I think we covered everything. We covered charity, I think we covered a lot today about these different documents, tools, and why you might need them, how to coordinate them, how often to get them redone or review them, make sure they're accurate. So any other questions? Oh, we have one more. Once you set it up, do you need to update paperwork with an estate planner or on your own?
Great question. We tell people, don't write on your estate plan, right? When people make notes on their plan, it adds ambiguity. And if we aren't sure what you meant by that on your death, there could be fighting, So rule of thumb, go back to your estate planner, update it with them, and make sure that done properly, because one of the things that we often see when, in addition to ambiguity, is if people make an update, did they properly notarize it and get it witnessed? And if they didn't, it's not valid under state law. So the technical requirements for signing it isn't right. So lawyers know how to do that, and they make sure that it's right.
And typically the update doesn't cost nearly as much as the initial plan. It's just an amendment to your plan. So the attorney just writes up the amendment. It's a couple extra pages that you put on the back of the trust about how things have changed for you, what you're changing, and just the amendment needs to get done. So it's a much shorter, easier, quicker process, and not nearly as costly to have an amendment done, an update done.
Correct.
Are these documents submitted to the state or held personally?
Great question. So no, way back in time, before we had, scanning into the cloud, a lot of people would submit their will to the probate court for safekeeping, so that if anything happened to them, we knew that the court has custody of it. Some lawyers still do that, but it is not necessary. All of our clients get a binder. We have everything scanned. We share that information with your financial advisor so that they have copies of it. And if you want electronic copies, you can have electronic copies as well, but one original, and we do not share it with the state or any government entity because we don't have to.
So like I'm the executor for my mother's estate, and so I have a copy of it all. But if she didn't want me to have a copy of it, because sometimes families don't want that all aired out there in advance, then she could just tell me who her attorney was. And if should anything happen to her, I could reach out to the attorney and get what I needed.
Mhm. Yep.
So
We
great
always tell
question.
clients that you should, when you're done, put it on the shelf or put it in your safe or whatever, but tell somebody where it is. Say if something happens to me, go here, grab this, and then you know what to do, you know where to go, you know where to call.
Mm-hmm. Great. Well, I think that's it. That's all the questions we had. So, Tim, thank you so much for taking the time today to share your expertise with this
Absolutely.
community. We really appreciate it.
Yeah, my pleasure. Thank you.
Yes, thanks to both Tim and Melissa for sharing this very helpful info with our alums. There's a link in the chat to the recording and slides will be online. And thanks everyone for attending, and hope you have a great rest of your day.